Introduction. Cypherpunk Dress-Up Day. As I rounded the corner from the elevator on the 19th floor of the Federal Building in San Francisco, I could see that the crew that gathered in front of Judge Marilyn Hall Patel's courtroom was definitely not your normal courthouse fare. Standing and even sitting on the majestic marble floors were well over 30 people. Mostly pale white men in their 30s, with longish, stringy hair. They were uniformly scruffy and awkwardly dressed in suits and ties. They all seemed to be in outfits that their mothers had picked out for them for a family wedding. Or maybe I was just projecting. I was 32 years old, worried about my hair, and wore a suit that my mother picked out for me from the Denver department store where she worked. They may have been a motley bunch, but they warmed my heart. They were there to show support for me as I argued a case called Bernstein versus Department of Justice. It may not have looked like it, but it was obvious to me and that crew gathered on a cool San Francisco morning in September 1996 that what happened in that courtroom would be crucial to the future of the internet. How Judge Patel ruled would play a major role in determining whether people would have privacy online. I must have seemed nervous because my co-counsel, Jim Wheaton, looked over at me. He touched my elbow and said quietly, "You're in your mother's arms." With that, I pulled open the heavy wooden doors and walked into the courtroom. Privacy isn't what you think it is. Privacy isn't what most people think it is, at least not entirely. It's not a secret coat of anonymity you throw on before doing something embarrassing. It's not about keeping your passwords safe or your sex life hidden. It's not even about freedom of the mind. Yes, all of those are pieces of privacy, but they aren't the whole thing. Privacy scholar Daniel Solove has done more than anyone else to try to enumerate all of the pieces of privacy, and he rightly articulated it as including freedom of thought, control over one's body, solitude in one's home, control over personal information, freedom from surveillance, protection of one's reputation, and protection from searches and interrogations. But Professor Solove also pointed out that it's far more helpful to talk about what privacy is for, rather than what privacy is. For individuals like you and me, privacy is fundamentally for control, for giving us control over who can know what we do, where we do it, and who we do it with. In that way, privacy is fundamental to our individual safety, dignity, and human rights. But here's the broader, less talked about thing that privacy is for, one that has animated my work for 30 years. Privacy is a check on power. Privacy limits the power of individuals over each other. It limits the power of governments over us. It also limits the power of corporations over us. Privacy allows people to protect themselves while creating a space to think, connect, communicate, share, and most critically, to organize for change. Put another way, privacy is important to each of us individually, but it is also important for all of us. Safeguarding privacy is part of safeguarding a free, open, and democratic society that supports everyone's rights and liberties. The protection that privacy gives us isn't just theoretical. At EFF, we've worked with people who have suffered harassment, assault, arrest, torture, and even disappearances facilitated by surveillance of their online accounts or devices. Some are domestic violence victims trying to escape their abusers. Others are members of disfavored minority or marginalized groups. Others are activists, journalists, or lawyers. The range of people at risk from their digital footprints is wide and growing. In 2023, a mother in Nebraska went to jail for discussing an abortion with her daughter using Facebook Messenger after Facebook was required to turn those messages over to law enforcement. Text messages between friends were used as the basis for a lawsuit against them in Texas for helping one of them seek an abortion. The issue of reproductive freedom in the United States after the Supreme Court struck down the federal right to abortion has awakened many Americans to this truth that members of marginalized groups, human rights defenders, and journalists have faced for years. The lack of privacy can be very, very dangerous. Privacy's historical importance in checking power is clear once you start looking. In the Civil Rights era, the Supreme Court expressly recognized the connection between privacy, the First Amendment, and dissent by rejecting an Alabama law that required the NAACP to reveal its membership lists to a hostile state government. Separately, and just within my lifetime, we've moved from a situation in which privacy was necessary for the safety of those discussing the idea that gay people should have the right to love and marry who they choose, to this right being vindicated in the Supreme Court. Most people remember the public parts of those fights for justice, the protests, the lawsuits, the congressional debates. But each of those fights required privacy in order to get started and to resist brutal backlashes from governments and other opponents. Privacy was also critical to the founding of the United States. Jefferson, Adams, Madison, and others needed to have many private conversations to create the conditions under which they could check the power of their colonial rulers. They even used an encryption method developed by Jefferson as they plotted and carried out a revolution over great physical distances. This is like thousands of other activists for freedom and justice around the world who have needed privacy to help them organize. It is no accident that controlling and surveilling how citizens communicate is consistently one of the first moves of a dictatorship, or that finding ways to avoid that surveillance is a key step for freedom movements. The digital era presents new challenges for privacy. This is something the founders of my organization, the Electronic Frontier Foundation, or EFF, saw in 1990. Some of these challenges are technical, and others are legal. Technically, it is much easier to surveil thousands or even millions of people digitally, especially since all of our digital communications and activities pass through a series of third-party service providers. Legally, the law still treats the non-content parts of our communications, called metadata, as I'll discuss more later, as deserving of less privacy protection, even though the collection and analysis of metadata is an extremely powerful way to spy on us. Worse, both of these challenges have been supercharged by the online surveillance advertising business models that emerged in the early 2000s and have become ubiquitous. While I care deeply about personal privacy, this public purpose of checking power is why standing up for privacy has been my life's work. Over the years, I've taken on the intelligence community, the FBI, and the tech and telecom giants, each time trying to protect and enhance the check on power that privacy can provide. Because if we can do that, we can create the space necessary to push the needle online towards human rights, freedom, and democracy. And if we fail, we face what the digital world could easily become, the most repressive, controlling, and authoritarian space ever created. We could end up with what Senator Frank Church in 1975 called total tyranny, and what more recently NSA whistleblower Edward Snowden called turnkey totalitarianism.